Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is actually my AI avatar, presenting from a script that I've personally written and approved. If you're a startup founder trying to raise capital, but you're not quite sure what your business is worth yet, you've probably heard of something called a SAFE or simple agreement for future equity. It's become one of the most popular ways for early stage startups to bring in funding without getting bogged down in valuations or complicated investor negotiations. Today, I'll explain what a SAFE is, how it works in Australia, and the key legal and tax considerations you need to know before signing one. A SAFE is a simple contract between a startup and an investor. The investor provides funds now in exchange for a right to receive equity later, usually when a priced funding round, a sale, or an IPO takes place. It was originally developed by Y Combinator in the United States as a more founder-friendly alternative to convertible notes. Unlike debt instruments, SAFEs don't accrue interest, and there's no maturity date. The investor can't demand repayment. Instead, the SAFE simply converts into shares at a future event, based on pre-agreed terms like a valuation cap or discount. The beauty of a SAFE is in its simplicity. It delays valuation discussions until the company has more traction, and it allows startups to raise funds quickly without the burden of complex documentation or investor control provisions. Now, here's where things get interesting. In Australia, SAFEs aren't defined under the Corporations Act, so their legal status depends entirely on how the agreement's drafted. If you're offering SAFEs to investors, you need to ensure you're complying with the Corporations Act, especially the disclosure obligations under Part 6, D.2. Unless you qualify for an exemption, like the small-scale offering or the sophisticated investor exemptions under Section 708, you may need to issue a disclosure document. There's also a risk that a SAFE could be treated as a financial product, particularly if multiple SAFEs are issued as part of a managed investment scheme. That means ASIC could scrutinize the arrangement, so careful structuring is crucial. When the triggering event happens, usually your next priced equity round, the SAFE converts into shares. The conversion can be based on a valuation cap, which limits the maximum company valuation for the conversion, or a discount rate, which rewards early investors by letting them convert at a reduced price. You'll need to define what counts as an equity financing event, whether the SAFE converts before or after that round closes, and what class of shares will be issued upon conversion. You'll also want to cover what happens if the company becomes insolvent or if there's a sale before the SAFE converts. In other words, while SAFEs are marketed as simple, the fine print really matters. Poor drafting can easily lead to disputes later, especially if the Constitution doesn't clearly define share classes or conversion rights. From a tax perspective, the Australian Taxation Office hasn't issued formal rulings specific to SAFEs, which can make things tricky. Because SAFEs aren't technically debt and don't immediately grant equity, there can be uncertainty about when tax liabilities arise for both the investor and the company. For example, when the SAFE eventually converts, the value of the shares issued may have tax implications. That's why it's always smart to get both legal and tax advice before entering into a SAFE to avoid any surprises down the track. Meanwhile, ASIC has not published formal guidance on safes, but it may still review them to determine whether they constitute a managed investment scheme or involve misleading conduct under the Australian consumer law. The main advantage of a safe is that it allows founders to raise capital quickly without getting stuck negotiating valuation or giving up control early on. There's no interest, no repayment requirement, and the costs to prepare one are generally lower than for convertible notes or traditional equity rounds. For startups that are still finding their footing, safes can be a great bridge between early funding and a later fully priced round. However, safes are not without risk because there's limited case law in Australia and no legislation specifically governing them. They are treated purely as contracts. That means their enforceability depends on how well they are drafted. Founders can run into serious problems if they miscalculate their valuation cap, use inconsistent discount rates, or fail to include a proper conversion mechanism. Some template safes, even ones from respected organizations, can be overly investor-friendly or founder-friendly, depending on the source. That's why customization is essential. If you're considering a safe, don't assume it's a one-size-fits-all document. Engage a lawyer to review the terms, even if it's based on a template. The key variables like the valuation cap, discount rate, and conversion conditions must reflect your company's unique situation. You should also confirm that your safe won't breach the Corporations Act and that your investors qualify for an exemption under Section 708. And most importantly, make sure your constitution allows for the creation of the relevant share class once conversion occurs. A safe can be a powerful fundraising tool for early stage startups, but only if it's done right. Its simplicity is appealing, but its flexibility can also create legal and financial risk if not handled carefully. At Leo Lawyers, we help startups and investors draft and review safe agreements that comply with Australian law, protect your rights, and reduce risk. If you'd like tailored legal advice before issuing or signing a safe, you'll find our contact details in the description box below, or visit us directly at leolawyers.com.au.